Good morning, everyone. Today I wanted to, as promised, turn you all into experts on how to file a provisional patent application so as to protect your intellectual property. I was talking before we started about a friend of mine who called me from Malibu last night who has designed a competitive bathing suit specifically for women. She knows nothing about patents and everything about bathing suits. And in the space of about 2 hours, she was able to understand exactly how to go about filing a provisional patent application. And by 6 a.m. this morning, she had already filed her provisional, which I tell you about this because it illustrates how easy it is to file a provisional patent application. So there's nothing to fear in filing a provisional patent application. You're all up to the task. And it's all something that you can do online by simply going to the United States Patent and Trademark Office website. So all you have to do is Google USPTO provisional patent application. The website comes up. You establish an account with the website, and all you need to do that is an email address and a password, and you're literally off to the races. Everything can be done online. I'm sorry, did I hear a question? Did I hear a question? Nope, okay. Anyhow, so this whole process begins with the America Invents Act. You remember the last class we talked about the AIA, because it was that law that was passed in 2011 by Congress that brought the United States into the 21st century, at least as far as the rest of the world is concerned, when it comes to patent law. This particular act has greatly simplified the application process for inventors in the United States and bringing us into conformity with the rest of the world by turning us into a first to file jurisdiction. But it's unique also among the other countries in that it provides you with this grace period. The United States is the only country, at least that I'm aware, as of today, that is a first to file state and also has what is called a provisional patent application process. The whole idea behind a provisional patent application is to recognize that the United States is now a first to file jurisdiction, but the provisional patent application was specifically designed to deal with this and the effect it has on inventors. And the provisional application gives a simplified process for filing a patent application that gives you a 1-year grace period. So it eliminates all the problems that inventors used to have when it came to disclosure and publication and proving that they were the first to invent rather than the first to file. All of those problems are eliminated because whoever wins the race to the US Patent and Trademark Office owns the patent. No ifs, ands, or buts. It doesn't matter whether you invented it first or thought of it first. Really, in almost every circumstance, whoever wins the race to the USPTO owns the patent. And the reason for the provisional patent application is to provide inventors like you an opportunity to disclose your invention without losing those rights. All you have to do is file a provisional patent application. And remember, we were talking earlier about the dissemination of scientific information, publishing your findings in peer-reviewed journals and things like that. In the bad old days, when you would publish in a journal, that would usually begin the clock ticking. If you didn't file shortly after that, you stood a very good chance of losing the race to the steps of the U.S. Patent and Trademark Office and losing your invention because somebody else would file ahead of you. So now those fears have been addressed by the United States Patent and Trademark Office by the provisional patent application. So let me go over with you the requirements of a provisional patent application. All right. So what do you need for a provisional patent application? Well, first of all, you have to understand that it's an interim patent application. It only lasts for 1 year. If you don't do something with it in that 1 year, you lose your rights. So think of a provisional patent application as a way of getting your foot in the door. And the goal should be within that 1 year period of time to convert this provisional patent application into a non-provisional. Because if you're interested in patent protection for your invention for 21 years, this isn't going to do it. At some point during that 1 year grace period, you're going to have to file a non-provisional application. What we say in the business is you need to convert your provisional application into a non-provisional application in order to protect your rights.
I have a question on that.
Shoot.
So you said it typically takes over a year for these to even be reviewed. So would you have to submit an official patent application before your provisional's even been reviewed, or is it from the time of review?
Nope, you have 1 year, so you'd have to file your non-provisional somewhere within those 365 days. In fact, the review time for a provisional application is around 24 months. And the review time for a non-provisional application nowadays is 3 years. But that's not the important part. The important part is protecting your intellectual property. What this does is it gives you that, well, we'll call it good housekeeping or USPTO seal of approval. It establishes a date on which you file. And so as to everyone else, every inventor in the United States and every inventor or someone that wants to practice the technology throughout the world, it establishes that date on which the invention was registered. And that's key, not only with respect to the commercial exploitation of the technology, but also when it comes to disclosing it. You may want to disclose it in a peer-reviewed journal, in which case this protects you. Remember, we're a first-to-file state, so if you disclose before you file a provisional, anyone who reads your peer review article, your PhD thesis, can run down to the USPTO and patent that technology if you have not exercised your provisional application rights. So think of this as a way of getting your foot in the door and solving all the other problems as against other inventors or practitioners when it comes to establishing a date for ownership. The other thing it allows you to do is it allows you to commercially exploit your technology. You know, the USPTO has its schedule, but you may have your own. You may want to, you may be, for instance, working at a company that has a deadline to produce an object, some sort of invention. So you have your deadline, the USPTO has their deadline, but by filing a provisional, then you can comply with your deadline without fear of losing your intellectual property rights. It allows you to go to a bank or go to investors. These are kind of practical things that I know students don't think of that often. But as soon as you walk out that door with your diploma into the cool world of entrepreneurship, and you're either working for a startup or you're working on your own, you're going to realize that money is what drives the commercialization of patents. And so you need to line up investors. You need to borrow from friends or from banks. And this enables you to do this without, once again, fear of losing those intellectual property rights. And that's the key. Any disclosure before you file your provisional patent application creates risk for you. And so when in doubt, file the provisional patent application.
I have a quick question. How
Yes.
long did you say the review process is?
Well, in most cases, of course, the answer to this question is it depends, okay?
Yeah.
But in most cases for provisional, if you filed it today, you're going to think about like maybe 24 months.
So but the protection only lasts a year. So
That's
I
right.
guess, is it almost effectively giving you 2 years of protection?
No, it's only given you 1 year. What it allows you to do, even before the examiner has reviewed and approved it, it allows you to use the term patent pending. It allows you to get certified copies to give to investors. It's vitally important that you understand that now that we're in a first to file jurisdiction, that's the key. In a way, we don't care how long it takes the USPTO to review our provisionals because we're interested in protecting our intellectual property. So, I don't care if they take 5 years. What I'm concerned about is protecting your intellectual property rights. And by the simple act of filing, you do that. Like I said, think of it as getting your foot in the door, because really that's all it is. And so you can go to a bank, you can go to investors, you can disclose in peer-reviewed journals, you can say it's patent pending, whether or not the USPTO has actually approved it or not. The key is protecting your rights. Yeah.
Yeah, I think that's a great point. On the flip side, do you see some people abusing that in the sense like they know it would never actually be approved, but they still file the provisional so that they can try to squelch some competitor or something?
Absolutely, positively. Great question. You're gonna, that's the kind of question I expect from an entrepreneur, not a student, but you absolutely hit the nail on the head. This is a way of sometimes controlling the marketplace. Now, with a provisional patent application, you can't file an infringement action. So until you have a non-provisional patent application approved and receive a USPTO registered number, you can't file an infringement action. But this begins the process. The old saying, begin at the beginning. This is beginning at the beginning. Everything else flows from the date of filing. That establishes everybody's rights. So if later on you find that somebody is practicing your technology, whether you happen to be a troll or whether you happen to be someone that is legitimately trying to protect their IP rights, this date controls. The date that you file your provisional controls. So, in a way, we don't care about the USPTO. What we care about is protecting your IP rights and protecting your right to commercially exploit your invention. And that begins at the beginning, as I say, with the first step in the filing of a provisional application. Okay? Any other questions? I believe if anything today, we understand the importance of getting our foot in the door. So like I was saying, this is a cheap, simple, fast process, except when it comes to the USPTO. But by the way, before you get an approval from the USPTO, you will receive an application number that you can refer to, and so your provisional patent will be given a number, which is all important for the application process going down the line. So it's not like you don't get anything from the USPTO prior to its approval. It'll be assigned a number, you'll get an email from them, and that's when you can start using the words patent pending, which, believe it or not, are really important when it comes to being in a first to file world. Okay, so and as I said, this gives you priority in a first to file world as opposed to other inventions. You'd be surprised at how many times two inventors working independently, one at a university in California, one at a prestigious technical school in Cambridge, will come up with the same invention at almost the same time. I've seen cases where one came up with the invention in May, the other one came up with the invention in June. The one that came up with the invention first filed in August, and the one that came up with the invention in June filed in July. Who gets the rights to it? The answer is
Person who filed first.
that's right. And it doesn't matter that the people at the university that came up with it first came up with it first. It just doesn't matter anymore.
The classic example is the Hall-Héroult process for reduction of aluminum that started Alcoa and Pechenay back in the 1880s. Charles Martin Hall got to the U.S. Patent Office 2 hours before the Frenchmen did. That wasn't first to file and rules and everything, but that's how Alcoa got the edge on Pechenay.
You know, history is full of famous examples now. The Book of Mormon, okay? The Book of Mormon was copyrighted in England by the people that own the rights to it hours before another party attempted to copyright it. The example is the same. There are so many examples I can give you of people who have come up with the same invention at the same time, or as you pointed out earlier, people who troll and try to exploit rights that they never came up with on their own, but were invented by others. I can give you example after example where you know, there were tremendous, people used to spend millions on lawsuits trying to establish who was the first to invent. And in 2011, when the AIA came along, that all went out the window, because now it doesn't matter who thought of it first, no matter who invented it first, no matter who published it first, it's who filed first, okay? All right, so for a provisional application, there are no forms, and it's really simple. All you need for a provisional application is a statement of the specifications. Okay, in other words, what is it? Okay, the US Patent and Trademark Office wants to know what area of technology is your invention in. They need to categorize it. They need to categorize it in terms of prior art. So, you know, a simple explanation is, you know, a mousetrap, a ceiling fan, okay? And a brief 1 or 2 sentence description of what it is all that's needed in the provisional patent application. The second thing you need is figures or drawings, okay? Now, every single application now, whether it's provisional, non-provisional, has to be accompanied by drawings or figures that show the invention and possibly how it works. Remember, I told you in the olden days, we used to have to bring an example or an exemplar of your invention into the USPTO. This is the substitute for that. So every provisional application has to have drawings. The third thing you have to have is what they call a transmittal letter. I don't know if I spelled that right, but a transmittal letter is just a technical term for describing who the inventors are, what the address of the inventors is, things like that. Just very, very, the fact that the name of the invention, the fact that it's a provisional application, all really, really, really simple stuff. Now, when you go on the USPTO website, you'll find that electronic forms come up that you can populate with all of this information. So in the old days, and even today, you can download an application and you can fill it out in longhand if you want. So there's that process where you can just download a transmittal letter or a cover sheet from the USPTO, which is all you need in addition to your specifications and figures. Or you can go to the forms online, the electronic forms, and simply populate them with the information about your invention there. Now, when it comes to inventions, a provisional application, these are the bare minimums. The specifications can be simply one sentence long. All you need is one figure. A transmittal letter naming the invention, giving the names of the inventors, giving the addresses of the inventors, is really all you need in terms of a cover sheet. So a provisional application can be very, very bare bones. But you can also, in a provisional application, get as technical and as complex as you like in these areas. What I usually advise people is to tell them that, remember, within 12 months, you're going to have to come up with a non-provisional application. So doing a little work early on when it comes to specifications and figures, some people use computer modeling to come up with figures now. There are demonstrating the software that you can do that creates illustrations that demonstrate how your invention works. So you can get as complicated and detailed in these when it comes to these bare minimum requirements as you want to. And I don't want to give you the impression that simplicity means that you don't do a thorough job. So my recommendation is always to be as detailed and thorough in satisfying these minimum requirements as you can be. Now, the last thing that a provisional patent application requires or doesn't require, depending upon who you're talking to, is claims. And that's why I put a question mark there. A provisional patent application by the statute does not require a claim section. And what is a claim section? We'll get into it a little bit more, but it's really simple. It just says what you claim your invention will do. I claim, or we claim, that my invention will cool a room, will catch a mouse, will produce aluminum ingots, will extrude aluminum from ingots into sheets, whatever it happens to be. So while a provisional patent application doesn't require a claim section, my advice to inventors is always to include at least one claim describing what you claim your invention will do. And we'll talk about it a little bit more, but claims are really important because they define the outline of your intellectual property. If you think of a piece of intellectual property as a house, and really, in terms of the law, there's no difference between owning intellectual property and owning something as tangible as a house. But if you think of intellectual property as a house, the claims would constitute the fence defining the property of the house. It's what you claim your invention can do that defines the limits of your intellectual property rights. Now, we were talking earlier, Zach, I think, was talking earlier about, patent trolls and people exploiting inventions for profit. Claims are an area where inventors try to define as much property as they possibly can. The broader the claim is, the more property you own. But remember, when we were talking last week, one of the things you have to do is demonstrate in order for the claim to be valid. So you can make a very broad claim here at the provisional patent application stage, but you may find yourself later on defending a cancellation or an infringement case based upon the overbroad description of your claims. So I always say that you, with a provisional application, you should keep it simple, be precise, but make at least one claim about what your invention will do. And if it does more than one thing, you know, like that ceiling fan we talked about last week, it provides, you know, cooling and temperature control in a room, but it also provides illumination. So there's an invention that does two things. So if I was writing the provisional patent application for that, I'd say that we claim that this fan will improve air circulation in a room. And I'd also say we claim that this invention will illuminate the room while it's controlling the airflow. So if your invention does more than one thing, you could consider a couple of simple claims. But you don't have to have a claim section in a provisional patent application. That's how simple it is. Okay, so let me talk a little bit more in detail about these specific sections and maybe talk a little bit about how you can be a little bit more detailed in them. Because the specifications section that's required in a provisional patent application is also required in a non-provisional application. So let's pretend we're going to be very detailed and fastidious in our specifications for our provisional patent application. Well, what do you want to include? Well, one thing you want to include is the title of the invention. You want to include the names and the addresses of the inventors. You want to talk about the background of the invention. In other words, you want to describe the technology area that your invention is in, or in other words, describe the problem that you're trying to solve. All right, that's called the background of an invention, and it can be one or two sentences, usually one sentence, and then a brief description of the drawings. So if you're going to include figures, and you have to include figures in a provisional or non-provisional, you want to include in the specification section some sort of legend that describes the figures. Figure 1 shows the mousetrap prior to being engaged. Figure 2 shows the mousetrap after it has been sprung. Okay, something simple like that. But in a specification section, you need to describe those figures and what they represent. The other thing that you want to include in a specification section, whether it's a provisional or non-provisional, is a detailed description of the invention. And we can go over some of those. I'll show you some sample descriptions of inventions. But it's a simple description in English about what your invention does. And sometimes this can be a little harder to describe, since a lot of us aren't that conversant with writing about what we think. But the specification section needs a sentence that describes in detail your invention and what it does. Now, if we're doing a really good specification section on our provisional application, we want to include in the specification a statement of claims. So we want to say, at least have one sentence about what we claim the invention does. And finally, there's an abstract section. And an abstract section is simply a short technical summary describing how the invention works. And I'll go over some examples of that as well. But those are the 5 or 6 things that you need in your specification section. Title of the invention, the names and addresses of the inventors, the background of the invention, that is describing the technology that's involved, like with my friend last night, competitive bathing suits for women. A brief description of the drawings, a detailed description of the invention, what it does, why it's different, why it's new, okay? In the case of my my friend last night who called about the bathing suit, she needed to explain to the claims examiner, as I told her, what made her bathing suit different than every other bathing suit on the market. And there were things about her bathing suit that really do indeed make it a competitive advantage for women swimmers that she was able to write. And I'll tell you, well, the people that know how to write a detailed description are the inventors. They're the ones that have been thinking about this for usually quite some time, and they're the ones that understand what their invention does most. So I always rely on the inventors to write the description of the invention. The sixth thing is the claim section, and the seventh thing is the abstract, or a technical summary of how the invention is to be used. So that's the specification section. Now, what I do want to talk about a little bit is about claims. Because as I said, they defined the property limits of your intellectual property, and for all purposes will define what you own. So later on, when somebody starts practicing your invention and you claim that they have infringed on your intellectual property, what we'll do is we'll go to the claim section. What the court will do, we'll go to the claim section. What the USPTO will do when somebody files a cancellation action against you because they think that you've overstepped, and the examiner or the court or the administrative judge will go to the claim section and see what it is that you said that your invention can do. And anything that falls outside of that description will not be protected. And everything that falls within that description, you're going to have to demonstrate that your invention can do. So if it happens to be a DNA sequencing invention that hasn't been demonstrated in higher animals, then your invention is going to be limited to that life form where you have been able to demonstrate in the laboratory that your invention has efficacy. And if it only happens to be single-celled animals or bacterium, then that's what the claims are going to, the limits of your claim, the limit of your intellectual property is going to be. If you've demonstrated it, however, in higher animals like human beings, then that will define the limits of your intellectual property. So the claims are terribly important. Every single word in a claim is vital, and I can't stress that enough. In many ways, this is the most important part of your application, other than your name and address, because this is going to define the limits of your invention. I have some claims that literally come out of the USPTO archives to share with you for purposes of illustration. All right, here's a claim for an automobile. A self-propelled vehicle comprising a body carriage having rotatable wheels mounted thereunder for enabling said body carriage to roll along a surface. B, an engine mounted in said carriage for producing rotational energy. C, a means for controllability, coupling rotational energy from said engine to at least one of said wheels, whereby said carriage can be self-propelled along said surface. This is an actual claim for what they called at the time, a horseless carriage. You can see some of the old language in there, but I thought it was an illustrative example of a claim because it shows how a claim just needs to be written in plain, straightforward language. Here's a claim for the method of sewing. Again, plain, straightforward language. A method for joining two pieces of cloth together at their edges, comprising of several steps. One, providing said two pieces of cloth and positioning them together so that an edge portion of one piece overhangs an adjacent edge portion of another piece. Two, passing a thread repeatedly through and along the length of the overlapping portions in subsequent opposite directions, in sequentially opposite directions and through sequentially spaced holes in said overlapping adjacent portions, whereby said two pieces of cloth will be attached along said edge portions. Again, straightforward description of what the claim of the invention is. I had one here. Well, here's a claim for concrete for you material science students. A rigid building and paving material comprising a mixture of A, sand and stone, B, a hardened cement binder filling the interstices between and adhering to sand and stones, whereby a hardened, rigid, and strong matrix for building and paving will be provided. Simple, straightforward claim for concrete. Now, we were talking yesterday, I think, about adhesives for the Tesla battery pack and how they were using different forms of epoxies and other materials in order to essentially cement these batteries into place, forming a fixed rigid unit. You can take this claim for concrete and take out the word concrete and some of the other words and describe an epoxy or a resin or some other material, some polymer that you use to create a solid surface. In many ways, something as simple as a claim for concrete can be adapted for other materials that have essentially the same purpose or perform the same function. You can see how whether it's concrete or an advanced polymer, you can see how the claim is written for something like that. Here's a claim for a pencil, a handheld writing instrument comprising a elongated core element, meaning that it'll leave a marking line if moved across paper or other similar surface. B, an elongated holder surrounding and encasing said elongated core element, means one portion of said holder being removable from an end thereof to expose an end of said core element, on and on and on. Again, a very simple claim for a pencil, but it would be the same or could be adapted for a pen or for a magic marker or for anything else that you might, any other writing instrument that you would invent. But as an outline for an invention, this is a simple, straightforward claim that can be used for almost any writing implement that could be invented. Here's a claim for a mousetrap. I won't go through the whole thing, but again, this comes right off a patent for a mousetrap, and it describes in boring, straightforward, clinical terms exactly how the mousetrap works. And that's the way to describe it. When you're writing a claim, or when you're writing an abstract, or you're writing a description of the invention, you want to be clinical. You want to explain yourself as if you're talking to someone from another planet who knows nothing about pencils or mousetraps or ceiling fans or DNA sequencing. Like I said, every word in a claim is important. It's absolutely vital because it defines the limits of your intellectual property. All right. So another portion of the application that we're talking about, and again, this can be included in the specification section of your provisional patent application, or will need to be included ultimately in the specification section that you send in with your non-provisional application, is the abstract. And an abstract is simply a short technical summary describing what your invention does. Again, in clinical, simple terms, what does the invention do? And the purpose of the abstract is to basically tell the USPTO examiner and allow them to quickly determine the nature of the technology that your invention falls in. So if it's swimming suits, if it's a logo design for an article of clothing, if it's a mousetrap, if it happens to be a plant patent on a new species, a new variety of flower or apple, in 10 words or less, you can explain to the examiner in the abstract section what area of technology you happen to be, your invention falls under. And it points out in this section, and this is the key, it points out what about your invention advances the art, okay? So coupled with the claims and the description of the background of the invention, that is, the technology or problem that you want to solve, it's your way of telling the examiner, this is how I put distance between me and the prior art. Every bathing suit, every competitive bathing suit up until now has done this. But now my suit does this plus whatever it is that it does. I wish I could tell you what this bathing suit does, but it's really amazing. This particular inventor that I'm talking about was a member of the U.S. Olympic swimming team back in the 80s, and has no engineering background, has no design background, but has worn a lot of bathing suits, and on her own came up with an invention which I think is going to make the people at Nike and the other people at Arena and everybody around the world who designs bathing suits sit up and take notice. I told her this morning that I think that she has stumbled on having become a millionaire because, and this is just somebody that, like I said, no engineering or design background, but somebody that has done a lot of swimming and understands the problems presented by swimming suits and understands the competitive advantages that can be gained in bathing suits. So it's the people that actually practice these technologies that tend to come up with the advancements in it. If you're working on Tesla batteries, you're likely to come up with an invention in that area. If your field is welding metals and you've been doing it a long time, it's likely that you're going to come up with advances in that field because you're familiar with it. If you happen to be a designer and you think in those terms, you're going to come up with a logo or an image that advances your client's interest in some way. Why? Because you're familiar with the technology. And so all of these things, specifications, claims, abstracts, are nothing to be afraid of and are not daunting or difficult when it comes to the inventors, because they understand. These may be abstract concepts, but when you sit down and actually with the inventor and you try to fit the invention into these categories, it's really pretty easy. The key is being as clinical and as clear in your descriptions as possible. Any questions? I think I got some abstract slides here for you to share with you. And I apologize if I'm not too good at this. I'm doing my best. All right, here's an abstract for aluminum illuminated fan blade. Remember that fan blade last week that I always get wrong on the test, that I couldn't imagine would qualify for a patent because I really didn't believe that simply changing the color or the material in a prior invention created enough distance between you and the prior art. I was wrong. It did get a patent. And here's the abstract from application. And again, the idea is to describe or point out what about the invention is new. So this one says a fan or other rotating device is illuminated using light projected from LEDs mounted in a circle about the axis. The light colors may be the same or different, and the device may be used for basic illumination or decorative effect. And I think that's probably what set the invention apart from all other ceiling fans in the mind of whoever the examiner was in this case, and probably led to the issuance of the patent. Again, they were able in ordinary language to describe how that invention advanced the art, created distance between it and other ceiling fans. Yes.
One comment I would make from having read a number of patents is pronouns are one of the worst things that we ever invented in the English language. They introduce ambiguity all over the place. And if you read a lot of claims, they don't use pronouns. You might say a fan blade which has a different coating. They would say, a patent drafter would say, the fan blade, which fan blade? I mean, there's an implied pronoun, or which is acting as some sort of phrase that it is standing in. The patent claims seem repetitive, but I found it actually using the techniques and getting rid of pronouns makes things much clearer and unambiguous.
I think that's a great point. You know, people are lazy with language. And when it comes to running into somebody at the grocery store and somebody says, how you doing? Well, you don't describe in the terms a psychologist or a medical doctor would describe your condition clinically. You say, oh, I'm doing okay. Well, what does that mean? That really means almost nothing, especially in the area of intellectual property. What you want to do is, a good example of claims writing, besides these that I'm showing here, have you ever read a medical record before? I mean, there's nothing as clinical. And there's a reason for that, because doctors create records because of continuity of care. They must describe exactly what's going on with a patient. So another doctor who comes along and takes over responsibility for that patient's care knows exactly what's going on with that patient. And so there's a way that doctors write that is clinical, that is descriptive, that is plain, that is simple, that doesn't use pronouns or adjectives. And you can learn a lot from the way medical clinicians write in terms of how to describe your invention. The best description I can give is that you want to be as clinical as possible in your description. So here's an abstract of a mousetrap. Here's an abstract, that's the cover sheet. But, a disposable trap comprising odorless rubberized glue or like sticky surface for capturing a mouse or like pest. A cover over the surface which has provisions for at least one opening therein for allowing the mouse to enter is disclosed. When a window or like is provided for allowing the user to inspect the interior to see if a mouse is trapped therein, and wherein externally activated internal bait means are provided, which bait is stored in an enclosure in a sealed condition, but which may be exposed within the cover trap by manipulating an external activator such as a push-up pedestal, which is pushed up to break a membrane within the trap and expose a change of bait material. Clinical, but it describes the 4 constituent elements of a mousetrap. A little door for the mouse to go in, something sticky that traps the mouse, a window so you can look inside the enclosure to see if a mouse is trapped, and a way of shall we say, disposing of the pest. But those are the four things that a mousetrap consists of. And there they are in sort of clinical, simple terms described for you. And that's what you need to do when you're writing your abstract. And again, these are adaptable. You know, if you come up with an invention that you want to do a provisional patent application on, my suggestion is you go to Google search, Google patents, and you look up the patents in the art that you're happening to want to occupy. You, for instance, bathing suits, and you look at the descriptions that others have filed when it comes to bathing suits. You look at the abstracts, you look at the claims, you look at the descriptions of the inventions, you look at the figures, and you say, how can I adapt these or improve on these? But they provide a wonderful sort of jumping off point for writing your claims or your abstracts or your descriptions. All right, any other questions? All right, so that's the story on provisional patent applications. That's all you need to know. When you go to the USPTO website, as I'm sure some of you eventually will, you'll find that all of these things are right there on the application, and you'll be able to say to yourself, oh yeah, I know what an abstract is. Oh yeah, I can describe an invention. Claims, now I know what to write here. They're all very self-evident on the application, on the online application, or the paper one that you get. And remember, this is a simple, fast, and easy way of going about protecting your intellectual property. It establishes an official date so that as against all others, we can determine who owns the intellectual property. It permits you to use patent pending. It begins, as I said, the Paris Convention. So as to all the other inventors in the world, remember, not the whole world doesn't have a provisional process that grants you this grace period. So if you're trying to exploit your invention or commercially take advantage of it in Japan or in China, those are, remember what we call them, absolute novelty states. And so in order to get the rights in those countries, you're going to need to establish a date for filing, which is earlier than anyone else. And for that, the provisional patent application serves a purpose. So it starts the clock running on the Paris Conventions, which all these countries, including the United States, are signatories to. It allows you to, in the interim, exploit your technology commercially without being afraid of losing the intellectual property. You can obtain USPTO certified copies of your application as proof of it when obtaining financing or in publishing. You can publish as much as you want because you've got a starting date. And most of all, it allows you flexibility. However detailed you want to get, remember, later on, you're going to have to do a lot more work for the non-provisional application. But it does allow you the flexibility of getting your foot in the door, winning the race to the steps of the USPTO, and then giving you something you can build on later on with your non-provisional application. That's what I got for you today. We'll go over infringement next week. I've got some fun stuff to go over on infringement, things that we encounter every day that maybe you don't realize have interesting stories behind them. Any questions though? If you do have questions, feel free to shoot me an email. If you have a particular invention and you're struggling, if my friends in California can call me at 11:30 at night to ask me how to file a provisional patent application, certainly you can. I'm happy to talk to you about your thoughts, your ideas, or questions you may have. So feel free to shoot me an email or call me at 11:30 at night. No problem with that, okay? All right, guys, that's all I got for you today. Hasta mañana. I guess I'm going to be here for Don's lecture, and I'm going to be watching your presentations. By the way, your presentations have been fantastic. Okay, guys.
Thanks.
Cheers.